Good morning, everyone. Welcome to the Arizona State Courts building and the Arizona Court of Appeals. My name is James Bean, and I've had the distinct honor and pleasure for the last 2.5 years to be a judge on the Arizona Court of Appeals. So on behalf of the court, we'd like to thank you, the Arizona Association of Defense Counsel, for your participation in our Connecting with the Community program. Our Connecting with the Community program started in 2002, and normally we take kind of a show on the road and do oral arguments for high school civics groups throughout the 8 counties that we have jurisdiction over. But I know for the last few years we've had the AABC come down, and we enjoy this partnership. I'm glad you all are here and are continuing this partnership with us all. So who do we have today? I see Judge Diane Johnson is in the courtroom today. Judge Larry Winthrop will come down later. Oh, you must have heard his name. Myself, Judges Johnson and Winthrop will engage in the Q&A after the oral argument as well. And it's going to be 40 minutes of take your best shot and 3 appellate court judges. So get your questions ready, and we'll do that after the oral argument. Today in the courtroom, we also have the lawyers in the case. We have Mark Breyer for the appellant, and we have Roger Strasberg for the appellee, JPO Insurance Brokerage. As I'm sure you all know, this is an actual case. This is not a moot or a mock. You'll be watching an actual oral argument before the Arizona Court of Appeals. And shortly, the judges will take the bench. Today's panel is presiding Judge Jennifer Campbell, Judges Marilyn Cruz, and James Morris Jr. Following the oral argument, the panel will exit the courtroom. We'll take a short 5-10-minute restroom break. The general public can be excused. We'll come back and we'll start the Q&A session at that point. So in just a moment, the judges will take the bench. Please silence any cell phones, any noise-making devices at this time, and please remember to rise when our bailiff wraps the gavel. So with that, we'll get started, and thank you again.
Good morning. Please be seated. This is the time and date set for oral argument in cause number CV18-0477, Symons versus PJO Insurance Brokerage. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you desire. Also, we've read the briefs, we've conferenced and discussed this case, we're familiar with the facts. At this point, counsel, you may proceed.
Thank you. Good morning. Mark Breyer for Brian Symons, my client, the plaintiff and appellant below. There's 4 things I want to address that may not have been as clear as I would have liked in the briefing that we did. 1, what this case is not. 2, how the court misapplied the law. 3, the court's total failure to apply in any way and therefore misapplied 26.1. And 4, the bait and switch that ultimately was done with the documented issue. I want to make sure I'm clear on what this case is not. This is not a case where the plaintiff is claiming that a witness was disclosed, but we just didn't have full disclosure and we didn't know where the witness was going. Or a defense was disclosed, but they didn't dot an I or cross a T. This is a case where instead what we're saying is a document that the defendant claimed to the court was hand in glove with their case, and a document the court later found in the denial of the motion for new trial was essential to the defense of the case, was never referenced, implied, disclosed, or given, not at the initial 26.1, not at the time of expert disclosure, not during a deposition, not at the time of the final joint pretrial, not at the time of the motion in limine, but literally after motions in limine had been filed 4 weeks before is the first time we saw it. Please.
We'll get in a moment into the issue of the switch that happened during trial. But first, what was the prejudice of the late disclosure? And isn't there discretion in the Superior Court to make that call, to allow it?
First, I would say It's a de novo review to the degree the court failed to properly apply a court rule, which is 26.1. There was no affidavit. There was no analysis. There is.
Hold on a second, because the rule also provides for allowing late disclosure in certain circumstances. So explain to me why we'd be de novo review, because it seems to me this is pretty clearly an abuse of discretion.
It is, well, two reasons why we believe it's de novo review, although I'll discuss why we believe there's abuse of discretion. We believe it's de novo review because the court allowed into evidence an insurance contract that legally did not relate to the case, and that is a failure to apply the law. Allowing the decision on whether an insurance contract applies under Sparks, which we cited, is a legal question for the court. The court never did any legal analysis and yet allowed an insurance contract to come into evidence. That part is a de novo review.
So that would be the relevance objection. But as far as the disclosure and discovery rulings, we're looking at whether the trial court abuses discretion.
With the caveat, if I may, Your Honor, to say that if the court, under the cases we cited in American Family versus Grant, does no analysis whatsoever under 26.1 and Rule 37, then it's the misapplication of a court rule, which is that part is a de novo review. You can't just ignore 26.1 and then say it's an introduction into evidence. The rule was never applied. However, even if we assume arguendo that this is an abuse of discretion standard under the American Family versus Grant case.
Let's pause there for a moment.
Please.
Okay. You said it was introduced into evidence. The actual document did not go to the jury, did it?
The document didn't, but if witness after I'm sorry. The document was shown to the jury, as is clear in the court record.
Okay.
It was addressed through witnesses, and their testimony is evidence. So when the jurors get to see a document and witnesses get to bring into evidence the discussion of that document, to the degree I'm being too liberal saying it came into evidence, ultimately halfway through trial, as the court knows, the actual document did not go back with the juror.
That would be correct. So when we talk about interpretation of that policy and deciding whether or not coverage applies, we're talking about a court applying a rule of law. It's a determination of law, correct?
There should have been a determination of
And
law.
there was a limiting instruction. The court, aware of your concern, did instruct the jurors specifically to disregard it for that purpose.
Well, I would say two things. One, if the document never should have been into evidence, then a limiting instruction to say ignore it is a different challenge.
You're saying the document
Yes.
never should have been admitted into evidence. And when we talk about that document, that I can agree with you. It didn't come into evidence, though. We have the discussion of the document, but we don't have that document going back to the jury. Agreed?
Absolutely agree.
And we have the court giving a limiting instruction saying you cannot consider it for the purpose of coverage of Mr. Symons' injuries. The only thing you can consider it for is the issue at hand. Was there negligence in the issuance of the Lloyd's policy? Is that correct?
I would only take small issue with the fact that the court did not give the limiting instruction as was just relayed now, Judge, because the court never said to the jury, there's been discussion of this document for these purposes. It does not apply. Instead, she took the Raji that generally would only apply to a defendant and just switched the names in the second half. So there was nothing other than a Raji instruction that put the name of the contractor into it. There was nothing that said to the jury, all this discussion you've heard should be specifically ignored.
So if the court's limiting instruction had specifically applied to DE's policy, you would be okay with it?
I wouldn't even be close to okay with it, Your Honor, and that's a fair question. My only purpose was to say we asked for a very specific limiting instruction because so much damage, in our view, had been done by a document for all the reasons we'll probably talk about, and I've briefed. So, no, I'm not going to suggest that I would have stood up and said that limiting instruction under all these circumstances, the totality of the circumstances, was acceptable, but at least then the limiting instruction might actually have carried some weight with the jury. And keep in mind, the jury for half the trial saw the document, heard about the document. It was argued to the degree we can call opening argument, but it was explained to the jury by the defendant that it was there as basically a collateral source rule. They should have used this document. To then not even address that incorrect issue through a limiting instruction is even less likely to be valuable than most limiting instructions.
Let's say I agree with you that the document was inadmissible for some purposes, which would be the kind of intervening cause type analysis that they tried to maybe introduce during trial. Why wouldn't it be admissible to go to the issues that the court determined it was admissible for, which is the standard of care almost?
Right.
This is an accepted industry practice, and this was not outside of this scope.
Two reasons, legal and factual. Legally, this document did not provide that coverage. And we know it didn't provide that coverage because, one, it was too late to do a legal analysis 4 weeks before trial. But in fact...
No, maybe I misspoke. I agree. Let's say we agree with you that it's not admissible to show that there was alternative coverage. But for the other element that they sought to introduce and use it for, which is to show that this was common practice to have subcontractors cover the insurance and that the paper general contractor does not.
I'm incredibly confident that the court did not misspeak, but I answered the question a little bit off base. If they wanted to bring in exemplar policies that would have existed at the time this agent fell below the standard of care, that could have been argued. This specific DE policy did not even exist. It literally wasn't created yet. So the suggestion that this policy created a year after the defendant fell below their standard of care could have been used to show what's done in the industry is flawed. And on top of that, if in fact what they're claiming in the industry happens is not true, now we're getting to 26.1 issues, but I lost my entire ability to be able to question their witnesses, more importantly, get my witnesses. I lived through the first part of this case, Judge, where we tried to get coverage and it was denied. And the insurance defense lawyer that had to get paid out of pocket tried to get coverage and it was denied. We knew full well this coverage didn't apply. And I know it from trying these cases. Usually there is an application. What was written in this particular Lloyd's of London policy did not provide any coverage. So to use the DE policy, you go, hey, here's what's done in the industry. But that's not what's done in the industry. In fact, in the industry, there aren't these holes in coverages all the time. And because we've gotten, my office and I've gotten verdicts.
But the DE policy, even though it was issued after the Lloyd's policy had been issued, isn't it still valid to show what's done in the industry? Because certainly the DE policy was issued before any litigation ensued.
Even if we ignore 26.1 for the purpose of this question, my answer would be no. If you want to find exemplar policies that would have existed at that time, and you have an expert who can somehow bring that into evidence, or even, I suppose, the agent, if he knew of those, the defendant could bring those into evidence. But the DE policy that did not exist, and there's no evidence that a policy like it existed, they took an after-the-fact policy.
How long after the fact?
I don't want to avow to the court because honestly I'm not certain, but it was about a year after the fact.
All right, but not in anticipation of litigation.
That the DE policy was created? Absolutely not in anticipation of litigation.
Right. So why would that not be an example of what's done in the industry?
Well, since no discovery was done on it, it's putting me in a difficult position to answer that question. This was one policy that may have no similarity to any other policy, and since I didn't have an expert or the time to address it or disclose it, all we know is they're taking one policy that, and the other piece, of course, is they're claiming this policy applies. If we assume, for the purpose of my answer, which I believe is strongly the case, but if we assume that this policy did not in any way provide the coverage they say, if we assume that, then to try to use it as an example of the protection in the industry, if in fact that policy doesn't provide that protection, and they have no other policies that provide that protection, then how can they use that as an example to excuse falling below the standard of care?
But when we address standard of care, we address it at the time the policy is issued. Blackstone was a, quote, paper contractor, meaning it had no employees, workers, builders, framers, cement, had nothing. And we're talking about what is the standard in the industry for a paper contractor.
Agreed.
And so that's fixed in time when the policy is issued. We're talking about not Blackstone's standard of care, we're talking about PJO's standard of care. So when we look at that, we don't look at it in a vacuum necessarily. What's done in the industry, and when you don't have employees and you push off that liability, why is that falling below the standard of care if, in fact, you require the policies and the certificates of insurance?
Well, the falling below the standard of care in this case was that there was a way that Blackstone could have totally protected itself and our judgment could have been paid.
Absolutely.
But the way to do that would have required the Blackstone owner to know of this huge hole in his coverage.
And so when we look at Patrick O'Neill's declaration and we look at all of the cover sheets and liability quotes, PJO disclosed it. Blackstone's principal, I mean, it says right here, it's X. No, what is not included? Injury to an independent contractor. So it was disclosed, but what we have is Blackstone's primary saying, I didn't read the policy.
Wait.
I didn't read it. So how does that go to PJO's standard of care?
Well, I think, and now we're going to get into the issue that our expert explained, but a general contractor with no employees is relying on his agent to understand the coverage he has. A jury is certainly in the position to make a decision as to whether they believe this licensed insurance agent did or did not properly explain the coverage to the general contractor. I'm not arguing, we did not raise on appeal, that there is no way under the evidence that was presented that a jury could have come to a defense verdict. We have all these other issues. If the court's question is, could the jury have believed this statement that, hey, you should have read the insurance contract and understood it, which, by the way, I do not believe is as clear. But in any event, could a jury have believed every word of the defendant said and come to that conclusion? That's a different question from what the court's asking. That is, could the jury have, had they been given the opportunity and this had not come up, could they and would they have been very likely to say, you're the insurance expert, you're the one that got this paid for, you sold this man, he thought he had $1 million of coverage, it's your job to explain, you have $1 million coverage with this huge gaping hole that is easy to protect, but let me tell you. And that's certainly something that's below the standard of care, at least it's a question of fact.
And when we look at the policy in the context of this litigation, you say they could have given exemplar policies, they could have explained industry standards. Wasn't the fact of secondary coverage going to come into this one way or another when we're talking about standard of care? Because wasn't Blackstone required to get certificates of insurance? Wasn't Blackstone under an obligation to do certain things to ensure that they were covered?
The fact that there was, that every single sub who showed up on the site had to have coverage was going to come into evidence. The idea that there was coverage that would have protected. Let me take a step back. If the court's saying, would it have come out that, hey, I sold this policy because I thought these other certificates of insurance would have been brought, and then he would have said, yeah, and I did get all those certificates of insurance. That's a very different question from what happened here, because what happened here is a very specific policy that was never provided. And again, I want to go back to my initial comments. It's not like they gave me 10 different policies. I knew what they all said, and number 11 came up at the time of the joint pretrial. What happened here is so much more abusive than that from a party that the record will show wouldn't file the joint report on their own. We couldn't get them to do it. Wouldn't give me the name of a mediator or a mediation date. Had to go to the court on that. Had to drag kicking and screaming all the way through court.
Go back to the original question that you were answering in terms of would it not come out in a trial that this policy required that those gaps be filled, and they in fact were, which shows that there was awareness on the part of the general contractor that their policy was as
Your Honor, I'm sorry. But Your Honor, they weren't filled. In fact, this contract that they put forward provided no legal coverage whatsoever to this defendant. So in fact, this contract to be presented to the jury, the judge should have done an analysis. Forget 26.1 for the moment. Pretend they gave it to me a year in advance and I moved and eliminated to keep it out. The judge should have done an analysis and said, under Sparks, is this insurance contract providing coverage or not providing coverage? If in fact it doesn't provide coverage, because in fact it doesn't provide coverage, because in the real world it didn't, and we know from the ISO that we quoted, it does not provide coverage. If it doesn't provide coverage, then to let a legally irrelevant document before the jury to be argued for any purpose would have been unbelievably prejudicial and inappropriate. But
Stop there.
Please.
We're talking about the standard of care of PJO. You're talking about an insurance policy that was issued to a subcontractor. So when we go back to standard of care of the insurance broker that issues the policy to Blackstone, How is he responsible for DE getting a substandard policy of insurance? Was Blackstone, I mean, how did it happen that way? Because it's not in the record.
Right. Well, that's what happens when we get a document with a few weeks to go. There is nothing substandard about the DE policy. We're not arguing the DE policy had anything wrong with it. The DE policy was never intended to provide the coverage that they made up out of whole cloth and called it hand in glove with their argument, that the court later found essential to their argument. If it's hand in glove with your argument, you probably want to share it. If the court finds it essential to your argument, I should have known in advance, because we could have, in our view, had we had the opportunity, which we showed with an affidavit after the trial, blown up the idea that there was nothing wrong with this DE policy. What was wrong is that the policy that was sold and the way it was explained by the defendant fell below the standard of care. And instead, there were all these other arguments. And I want to make sure I reserve some time for rebuttal, unless there's other questions before
I do have one more that I want to
Please.
just briefly, and we'll give you a little bit extra time, if that's okay.
Okay.
Just quickly. She's presiding, so I have to ask.
That.
You got it 4 weeks before trial, right?
Correct.
Okay, and you knew then at that point how they at least intended to use it for one, not the way they ultimately intended to use it, but one of the ways they intended to use it.
Yes.
Okay. Did you ask for a continuance?
No,
Did you
I
ask
didn't.
for more time to reopen the expert for yourself or anything like that?
Absolutely not. If I can address the reason. At that point, we had first of all, we didn't get the ruling that day. I don't know, I have it on my, over there, but this ruling comes in, let's say, 2 weeks before trial, 3 weeks before trial, and all I knew that they were going to use it for, which I thought was inappropriate. I thought by ruling eliminated, the court had already, this court will decide, but potentially had reversible error. My client had at that point been waiting through not one litigation, but two litigation for a chance to go to trial. Clearly, had I known that they were going to argue to the jury, hey, the key to this case is there's this other insurance that's there, he should have used it, I probably would have said, I have no choice, Judge, we need more time. But for the one, what I still believe to be totally improper use of that document, we did make a decision that said, I don't know how it's coming in, but it's coming in, and no, we did not ask for more time, and I would argue that at that point, with a party who has been completely unresponsive the entire time to show up, to restart discovery and go another year seemed like a very huge hill to climb for my client at that point. Thank you.
Extra minute and a half.
We're going 2. Okay. Can we give 2 minutes to both sides, please? Counsel, when you're ready. And we're going to wait until the clock gets set. You're going to get 2 extra minutes to use as you will. And the clocks up here, I've been informed, don't match the clocks over there, so we're at 4, 3, 2, 1, 22. Thank you, Demetra. Please proceed.
Thank you, Judge. My name is Roger Strasberg. I tried the case with Mark. My partner, Sharon Briggs, did all the briefing work, and she was selected to be here today to argue to you, and she wanted to be here today, but she came up with a vicious stomach virus, and she wanted me to express to you that she apologizes and she wished she could be here, and she told me not to mess up. So
No pressure, and tell her we hope she feels better.
thank you, Judge. I was thinking last night that maybe the way I could be most helpful to you is to just make some observations about the record, because when I was reading the transcript of the trial, you know, after a year and something, it doesn't read quite as clear as it sounded when we were doing it. So a couple observations, and mainly I'm going to address the arguments in the reply brief, because I think that's maybe where I can be most helpful. So the first one, it's at the reply brief at the first and second pages. The policy that the trial judge excluded, and I thought that was bad for me, but anyway, that policy, it wasn't disclosed improperly. It was in the hands of the plaintiff 7 months before the trial, it was in their hands 10 days before the deadline for the end of discovery. And I direct your attention to...
It was disclosed April 3rd, 2018 with your motion. No, that's motion for new trial.
June
When you
20.
filed the motion to add, and it was in June, correct?
Yeah, June 20, 2018, Judge.
And it was attached not in an appropriate disclosure statement, but they in fact received a copy of it. Is that correct?
Yeah, but more than that, Judge. They also got the affidavit of my contracting expert, Tom Billier, and that's in the record at IR 6267. And in that affidavit, because, I was trying to assert a claim against a licensed professional, so I needed an affidavit of an expert, and that was him. And he said that in his opinion, Blackstone, the general contractor, was negligent in failing to mobilize all of the available coverage by failing to tender and make a demand on DE's carrier of the Occidental policy. So not only did they have the policy 7 months in advance.
Okay, so 7 months in advance of trial, they have the policy, and how do they have it? How do they receive it?
It was attached to the motion to file a third-party complaint that was filed June 20, 2018.
And is that really the same as attaching it to a Rule 26 disclosure? Does that really put them on notice in the same way?
Well, yeah, I think so, in substance, if not in form. And the substance is provided by the affidavit of Billier, and the response by the plaintiff showed that they internalized the information, because in their response to that motion, they argued that there was no coverage because the DE policy only covered for DE's negligence and not for the negligence of the general contractor. They also argued that there was no coverage by reason of assumption of liability absent an agreement. But you see, there was an agreement here, and that was the subcontract. So, and that's at the record at this response is IR 71 to 72. Now, also in that response, you'll see in the paper the plaintiff says, oh, if I only had the time, I could have got an expert. Well, in that response, in June of 2018, the plaintiff had an expert. It was the same expert who testified at trial, Mr. Menard. And the plaintiff said in their response that he had, the expert had reviewed the DE policy and was of the opinion that it did not provide coverage for a bunch of reasons which we argued were in error. But I'm not really offering it for that purpose. I'm offering it for the purpose to show the awareness on the part of the plaintiff of what we were arguing, the significance of the policy, and why that coverage. Judge Campbell, you mentioned the word secondary coverage. And that's not exactly it. I see how it looked that way. But what it is it's, and this, in what came out of the record, and let me just kind of summarize, and then I can give you some places to go to. Nobody writes insurance, third-party liability insurance, for paper general contractors that don't exclude the subs, claims by employees of subs. And there's a reason for that. It's because...
Is this in the record?
Yeah, it is.
Because plaintiff's counsel just got up, or appellant's counsel just got up and told us essentially the opposite. So I want to make sure you're very careful and only telling us what we have before us in the record below.
I really appreciate that caution, Judge. And I got it here. I can read it to you.
Will you identify the document you are holding?
Well, these are my notes.
Oh, well, I don't want your notes. What document are you going to be referencing?
The record.
Where in the record?
It's the PM session 2/28/2018, pages 6219 to 6315. And here, this is the plaintiff's expert, Menard, and he says, I've been doing this for 27 years, and I don't know if there's a company out there or a risk retention group that would offer that kind of coverage. And what he's talking about is a Lloyd's policy without the sub-exclusion. I'm simply saying I don't represent one, and I don't know what that Mr. O'Neill does. Question. So as far as you know, such coverage doesn't exist, right? Answer. I haven't found it. And the testimony, the relevancy of this policy, the DE policy, was that it goes to the standard of care, the custom and practice in the industry. And you see, the DE policy in the industry, it's not really secondary. It's the primary coverage for claims by subcontractor employees.
So, Mr. Strasberg, if that is in fact the case, why did you need to use that specific policy would be my first question. Why not use exemplar policies? And my second question is, if that is the reason that you introduced that document or discussion of that document, why did you go on to argue about coverage under that policy?
Well, let's see. I argued coverage because I believe the plaintiff opened the door by referring to this hole in the coverage. But you see, again, the words were so critical in this case because it was all words. It's not a hole in the coverage. It's a hole in the Lloyd's policy that excludes claims by subcontractor employees. That is not a hole in the coverage because, and maybe it is a secondary level, the DE policy covers those claims. And it's understood in the industry that that's the way it works. And that's the testimony that came at trial. And I can, because the Judge Sanders, I mean, I lost. I lost on trying to get in the subcontract. She said, nope, you can ask him his understanding, but yeah, that's out. I lost on the policy of insurance by DE. She said, that's out. She said, you can ask him his, Reinheimer, you can ask him his understanding. And so here, I asked the expert, Mr. Bernard, and this was at the PM session 2/28/2018, pages 84.8 to 85.7. And I said to him, I mean, we were going through the expectations in the industry on how these claims would be handled. And I said, question, second claim by the employee against the general? Answer, Question, for negligence by the general. Okay, and let me make a footnote. That was the big, division between Mark and I. Because I said there is coverage no matter what. If it's a claim for negligence of the subcontractor, that's covered as an additional insured because 2010 only covers negligence by the named insured, and since it's stuck to the subcontractor's policy, that means the subcontractor, right? So additional insured 2010 forms only provide coverage for claims that arise from the negligence of the sub. But the policy also provides coverage where there is a claim related to the negligence of the general, but it does it in tandem with the subcontract because the subcontractor obligates the sub to indemnify the general, right? So it's an assumed liability, and that qualifies as an insured contract under the DE policy. And the only exception under DE was for sole negligence of the indemnity, right? And that wasn't here because the judgment that Symons got below was 80-20. So it wasn't sole negligence on the part of Blackstone. It was only 80%. So, and that was the argument for coverage. In the memo, I brought kind of, I know that we'd be pressed for time, and I just brought a copy of Defense Exhibit 48. Is that something that might be helpful?
Below?
Huh?
Was it in the record on appeal?
Yeah, the defense exhibit is.
We have access to it. So.
Okay. Well, what I just told you, that was in the memo we filed, and that was our argument on coverage. So there's a fundamental disagreement.
I mean, but aren't you asking us basically to say that Rule 26 doesn't require it if you do it some other way? I mean, the rules set forth very specifically what you need to do to properly disclose something so that they can know what arguments they're going to face. And the fact that you argued this in context of trying to interplead or bring in a third-party complaint to the thing does not put them on notice that you're planning to use this in your case in chief against them. How are you asking us to rewrite the rules to just allow that type of action? Or do you have another argument, which I think I understand, but let's see what you say first.
Well, that would be form over substance. I mean, the purpose of the rule is to do substantial justice, not perfect, but substantial. And also, I'm hoping I get the right one, the one you're thinking of. And also, the plaintiff, number one, I say, should have disclosed this to me in their initial disclosure statement because they knew about the subcontract and they have a duty to provide, information about arguably implicated coverage. Right? They don't get to do a coverage analysis and say, well, it doesn't apply, so nuts. And they didn't do that. I had to subpoena the policy, and when we finally got it, and it was disclosed, the plaintiff waited from June to, January to try to exclude it.
Well, yeah, when you put it on your exhibit list that you plan to introduce it, up until then, they didn't know that you were going, or they didn't have reason to know that you were going to actually try and introduce it during the trial.
No, I don't think so. I don't mean to interrupt, but I don't think so. And I think because of the whole argument. And see, that's when the plaintiff opens the door, because on opening statement, the plaintiff, he started this.
Well, let me touch that because I find that argument a little clever. When you have a specific ruling that a document can come in for a limited purpose, and you think that the door's been opened, isn't it incumbent upon you to let the court know that you think the door's been open and ask for a reconsideration of that ruling? Or do you think you can just say, now I've got a ruling, I can only bring it in for point A, but I'm going to bring it in for point B because they've opened the door, despite the explicit ruling before?
Well, the explicit ruling before on the motion in limine was that the judge was going to extend the deadline for disclosure, right, and rule on admissibility at a later time. The plaintiff...
And you had argued that it was admissible for a limited purpose in your response to the motion.
Well...
You said, here's what I want to introduce it for, and the court said,
no.
We'll rule on that later.
Yeah, we'll do it later. Right. But the whole argument was, the HOLE whole argument, the whole argument was...
I actually wrote down in my notes earlier on something you said, I wrote whole and had to scratch out the W.
Sorry. And here it is. This is the AM session, 2/27/2018, page 4. And Mr. Breyer says, good morning. The case you're going to sit on this week comes down to just one question. And here's the question. Did the defendant, as an agent, explain to his client the holes in the insurance, did he say policy? He said coverage. Not just the Lloyd's policy. He said coverage that he was selling. I also, now, what can I do? That puts the defense in a very prejudicial position, right? Because he said that my guy sold Reinheimer a pig in a poke that had a hole in it, right? Well, I stand up and I say there's no hole, right? Because there's other coverage. Does Mr. Breyer object? No. In fact, he went through the door he opened on opening when he cross-examined my guy, Pat O'Neill. And this is at AM session 227-2018, 48, 18-49-7. The cross was, you heard your attorney state to the jury that in effect there's these two policies, right? There's the policy you sold to Blackstone, and then there's the policy of the electricians, and the electricians' policy protects Blackstone. Did you hear him say that? Yeah. Do you agree with that? I do. Is it your understanding and testimony under oath before this jury that the lawsuit Mr. Symons brought against Blackstone would have been governed or covered by the DE electrician's policy? Is that your understanding? Answer, yes. So, again, in the AM session 40 pages later, at 60, line 20 through 61, line 9, says, question, again, cross of my guy. You're selling this coverage. Your lawyer said to this jury that you shouldn't be here. And I'm paraphrasing because the D's policy should have covered the lawsuit that left BSD almost a $500,000 judgment. Yes. Question, you heard that? Yes, I heard that. Question, but in fact, since DE Electricians was never alleged to have done anything whatsoever that led to the injury, the correct statement would be the only policy to protect this general, if it's the general's conduct that's alleged, is the policy you sold him. Answer, I'd probably agree to disagree, I guess, on that one. So, and I brought this up. I didn't just think this up for you. I brought this up to Judge Sanders. And in the AM session on 2/28/2018, page 30, I said, Judge, I think the plaintiff has left the jury with the belief that if the Lloyd's policy doesn't cover, then Mr. Symons' damages are the full $475. And that, Judge, is not so. And Judge Sanders, God bless her, I mean, she was engaged. She said, why is it not so? And I said, because the DE policy did cover that amount. The plaintiff, for whatever reason, chose not to pursue it and can hardly claim it was damaged by something that was brought about by its own actions. That's kind of like, you remember, one of the arguments for relevancy was intervening cause, and that's where that was going. So I hope that, did I answer your question? Okay. So really, again, there's a difference, I say, between the document and the existence of the policy. And that was the difference that Judge Sanders taught me. She really did. I mean, she made me see it in a new light. And the difference is that the existence of the policy shows that the expectation in the industry is being followed in this case. Because and this was testified to, I read that to you, the quote from Menard, that's the expectation in the industry, that if it's negligence by the general himself, then that's covered as an additional insured contract. So again, the threefold relevance of this testimony about the existence of the policy is it's proof of the standard of care. And that was the argument. We were arguing that the issue here is the appropriateness of the advice given to the agent. And this is PM session 2/28/2018, page 5 through page 7. And I argued to the judge, Mr. Breyer has suggested that the advice was inappropriate because there were holes in the coverage provided by the Lloyd's policy. The the advice given by O'Neill was to look to the AI and the subs policy as a way to fill what otherwise might be a hole. And that was admitted to by Reinheimer himself.
And time is up, counsel.
Sorry?
Time is up.
Am I up? Oh,
Yes.
sorry.
Thank you very much
well,
for
thank
your
you,
argument.
Judge.
Mr. Breyer.
Thank you for the extra 2 minutes. 3 things. First, I have a mea culpa. In my opening brief, I said, which was a relic from my post-trial motions before I had everything, that they provided this document 7 months in advance. If you actually look at the document, this was never provided. What they provided was the Occidental policy. The first time we were ever given this document, you can go and look at the motion, was 4 weeks before trial. Also, to address what Judge Morse raised, it was not in the joint pretrial list. One more thing that got violated. It was after the joint pretrial was agreed upon, after motions in limine had been filed. That's when we first got it. That's number one. Number two, to just go back to what this court has to do. If the trial courts clearly should have and do have the right to make decisions, and there's with the issues I addressed earlier, but even if we have an abuse of discretion standard on whether or not 26.1 was violated, there has to actually be an application of 26.1. In this case, the judge, neither in the hearing, which we've attached as part of the record when we were arguing the motion, nor in her ruling, nor has never done, the court never did an analysis. Was there prejudice? Was there reason for the delay? 26.1 was simply never applied. It was never considered. The argument was, well, this is essential to their case, and therefore it was allowed in. And as we referenced earlier, if there's nothing, and the court never does an analysis, if there's nothing in the record from which we could support why this document was never provided, why the argument was never provided until 4 weeks before, then 26.1 was violated, which is the court rule. Finally, and I'm sorry I'm speaking at that speed, I'm just trying to hit the 3 key things.
Labeled a track so far.
I will point out that I don't believe counsel ever answered the question as to why, if they wanted it, they keep doing this. Every time they're arguing to a court or in briefing, they argue the reason for this document is A. But repeatedly in front of the jury, they made a fully improper argument that said they should have availed themselves of this coverage. And remember, because the court precluded it and I had no experts, the jury never heard that, in fact, we did try to use this coverage. We tried to use it. The lawyer who was hired by Blackstone tried to use it. There was no coverage. The only discussion, because it was improper, was repeatedly made. Members of the jury, and I've attached enough of the exhibit for the court to know, but members of the jury, why are we even here? They're going against the rules. They have insurance they're supposed to use. They didn't use it. And the question was asked, but I believe not answered. And obviously the reason is that's a very powerful argument to the jury. Hey, there's other insurance that could have been used. They failed to use it. Finally, last, unless the court has other questions, this suggestion that we did not object about 100 times, we've attached part of it in our briefing. We begged, we pleaded, we did everything I felt we could to try to never allow this into evidence. It is frustrating as a trial lawyer when I'm just faking my way up here today on the appellate court. I try cases, and I understand. In fact, I don't like the gamesmanship of, you didn't disclose this, so where's that word? That's not what happened here. A whole new argument and new document was given and took away my ability to represent my clients. Thank you.
Thank you.
Counsel, thank you both for your arguments today. This matter will be taken under advisement, and we will issue a written ruling in due course. We are at recess.